This is Chapter 16 lecture video. You should have already read Chapter 16, have your PowerPoint for Chapter 16 up, and have your textbook in front of you. Let's turn to page 489, Myths and Facts about Identification Procedures. Myths. Eyewitness identification of crime suspects is one of the most reliable methods for correctly determining the perpetrator of a crime. No. Fact. Studies suggest identification of the wrong person by victims and witnesses is one of the most common errors leading to the arrest and conviction of innocent people. Myth. Most perpetrators are quickly identified by analysis of forensic evidence collected by police at crime scenes. It takes a little bit of time. Fact. Even where forensic evidence is found at crime scenes, identifying the perpetrator often takes a great deal of time and investigative resources if the suspect is not already known. Myth. Lineups and photographic lineups, frequently called six-packs, involve a victim or witness identifying a suspect from a random array of other persons or photographs. Just a side note, the reason why photo lineups are sometimes called six-packs is there used to be a requirement for there to be 6 photographs in a photo lineup, and that's why it was called a six-pack. Fact. To encourage accurate identifications, the array of persons or photos presented should be similar in appearance to avoid being unduly suggesting the person the police believe committed the crime. So you can't have identical twins or something like that. Myth. During a show-up, a police simply take a suspect to the victim or witness and ask if this is the person who committed the crime. Police sometimes call that a curbside. Fact. Victims or witnesses are usually transported to the location where the suspect is and admonished that it is just as important to exonerate someone who is innocent as it is to identify the person that committed the crime. All right, let's talk about this. Lineups, photo lineups, curbsides, six-pack photo lineups, identifying people. Let's talk about that. Slide 5. Typical kinds of police identification. Identifications are critical to police work. 3 basic types are used. Lineups. Multiple people are in a single group with one suspect are shown to the witness. Show-ups. That's where a single suspect is shown to the witness, and that's often called a curbside. Example of that would be a victim was robbed. Some guy grabbed her purse and pushed her down and ran off. Police right away, or Johnny on the spot, they get the guy, and then another police officer's with the victim, and they say, hey, we've got a guy in custody. The victim described him already, what he looked like. The victim hops in the police car. They drive by the suspect, and the victim says, that's him, or it's not, or no, that's not him, or yes, it is. That's a curbside viewing or a show-up. Photographic lineup. Multiple photos are shown to the witness, either in groups or sequence with the suspect included. The photos that can be used could be booking photos. They could be field interview photographs that were taken previously. I teach my forensic students how to do field interview photographs, basically mugshot photographs, really. And so it can be a variety of different photos that can be used. We'll talk about that a little bit more. Page 489, middle of the bottom paragraph. Factors such as poor lighting at the crime scene, the witness's impaired vision, and only having a fleeting glimpse of the perpetrator's face, that can't be controlled. Page 490, bottom of the first paragraph. Testimony about an identification procedure infected by improper police conduct is not admissible if there is a substantial likelihood of irreparable misidentification. The court made it clear, however, that the defendant has no constitutional right to suppress testimony about identification procedures that were not arranged by the police. So it's talking about police arranging it or not. Bottom of definitions used for identification procedures. Having an eyewitness identify the perpetrator in court has an enormous impact on the jury. Unfortunately, the witness may not be correct. For example, erroneous eyewitness identification was a major factor in about 75% of the over 300 cases handled by the Innocence Project, in which DNA exonerated individuals sentenced to prison. One of the things in court, a lot of times, the prosecutor will ask the victim, can you identify the defendant to the jury? And the victim or the witness will point to the defendant and say, that's him or that's her. A lot of times people look different in court than they did when they committed the crime. They clean up for court. One time I processed this VCV, Barrio Chula Vista gang member, and he had a great big tattoo across his head, and that was gang related. I'm not going to say what it was. Well, I show it in my forensic classes, but it's a big, very distinct tattoo. And for court, his hair grew out, so you couldn't see it. Otherwise, the jury would see it very clear, and that obviously... And he had a bald head when he stabbed a guy and killed him. And for court, he grew out his hair. It looked totally different. So a witness might go, you know, it can kind of throw them off a little bit sometimes. Slide 6, Fourth Amendment rights cannot compel a suspect to participate in lineup absent a consent or lawful custody. If they're in custody, you're going in the lineup, or unless they consent. But brief detentions for show-ups may be possible, like that guy that grabbed someone's purse. They might be able to be detained if you have probable, reasonable suspicion. But overall, you need probable cause to transport for a lineup. The Fourth Amendment applies to any detention. Photographic lineups are not a detention. So if you've been arrested before, your photo could be used for a photo lineup anytime they want to use it. Page 492 at the bottom. The police do not have the authority to detain a suspect in order to conduct a lineup or show up unless the detention complies with the Fourth Amendment. So random hunch stops are not allowed. Neither may be people be detained because they fit a general description. It has to be more than that. Bottom of page 493. Probable cause to arrest is necessary in order to transport the suspect. Once at the police station, either a lineup or a show-up may be conducted. Identification procedures do not have to be related to the crime for which the suspect was arrested. Let's look at slide 7, Fifth Amendment rights. There is no right to refuse to participate in a lineup. The fifth right is your Miranda rights. That's only for testimonial questioning, testimonial evidence. You can be compelled for a lineup. You can be compelled to pose. You can be compelled to wear specific clothes or to speak specific words. I videotaped a lineup of a robbery one time, and everyone in the lineup had to put on glasses, and they had to say, I think it was, "Give me all the money," something like that. So you could be, the people in the lineup may be told a specific phrase that they have to say. Slide 8, United States versus Wade. Billy Joe Wade was arrested for bank robbery. Wade had counsel appointed to represent him. He was compelled to appear in a lineup without counsel being present and was identified as the robber. On appeal, the Supreme Court ruled that counsel must be present, or it may constitute a violation of the Sixth Amendment, not necessarily the Fifth Amendment. You have the right to counsel to be there if you're arrested and you're in a lineup. Slide 9. Generally, a suspect has no right to have counsel present, but after arrest, counsel may be present. But counsel does not run the lineup. They don't run the show and say how it's going to go. Counsel observes conditions and may object to admission of identification if it violates due process, and that would be in front of a judge. Slide 10, Kirby versus Illinois. William Shard was robbed by two men. Police stopped Thomas Kirby, who was arrested and taken to police station. In a show-up, Shard identified Kirby as the man. It was not a violation of the Sixth Amendment right to counsel because the show-up occurred before the beginning of the criminal prosecution. Slide 11, Moore was arrested for rape. The victim was shown Moore after hearing evidence of his guilt. At trial, she testified the identification was made in part based on the information provided by the prosecution. The Supreme Court ruled the identification violated the right to counsel was improperly suggested. So in other words, this victim, who was a victim of rape, had heard some evidence that this guy was guilty. So that a victim should never know the evidence at that point, and then given a photo lineup or knowing who he is and knowing there was some evidence of his guilt and then saying, yep, that's him. So that's a problem there. In that case, that was definitely found to be a problem. Slide 13, due process. Procedural due process, constitutional requirement that whatever method used is fair, cannot create a bias against a suspect, like an identical twin, or your suspect's white and you have all African American or all Asian, and and your suspect's white or something, something like that. That would be biased. Or your suspect has facial hair and everyone in the lineup doesn't. Things like that would be biased. Typically, you must avoid undue suggestion that the suspect is the guilty party. Individuals must have similar characteristics. Please read on your own the National Institute of Justice, or NIJ, guidelines on page 499 regarding established guidelines for lineups. And also please look at figure 16-4 on page 500 to see basically a diagram on due process or suggestive lineups. Slide 15. Ooh.